Alex Spiro, welcome to Office Hours.
Hi, how are you?
So I'm so glad to have you as a guest because you've been on both sides of the criminal justice equation. You served as an assistant district attorney in Manhattan, and then you transitioned over to the defense side. Recently, you authored a letter on behalf of your client, Jay-Z, and many other hip-hop artists, including Meek Mill, Fat Joe, Kelly Rowland, calling on the legislature and the governor to enact the rap music on trial bill. And I want to talk all about the bill, but before we get to that, I want to discuss the issue. So how common is this problem? How often do you see rap lyrics actually being used in New York and across the country?
At trial and up on appeal and in case law that then gets digested by lawyers across the world, not that readily, but at bail hearings and sentencing hearings, far more often than people realize. And so all one needs to do is go into a courtroom in Manhattan or the Bronx or Brooklyn, walk in and listen to a bail application from a prosecutor where there's a 17-year-old kid, he's accused of doing something, and they say, and by the way, judge, if you look at YouTube, he's dancing in this video and there's somebody wearing a red handkerchief in that video, and we think he might be associated with violence. He might be associated with a gang. Listen to the music. And the judges, for their part, aren't in a position to really vet that information. And they come, they're generations older. They come from a different memory and different place in time, and they can't siphon through what's real and what's not. And that leads to the criminalization of those very lyrics. This system in this country has hundreds of years of backwardness and mistakes on these issues. So the jury that you're in front of is often an almost all-white jury, right? And so you have an almost all-white cop base, or a cop base that is not from the same community in which they police. You have an older Caucasian judge, most likely, in all likelihood. You have a mostly Caucasian jury, and you have now tainted them with information that's just not relevant. So the question is, why would you risk all of that? Why would you try to stifle speech and creativity in music? The pros and the cons of that don't make sense. And we don't want to leave that for judges to decide. We want to codify that in a law that says it's enough already.
Okay, let's transition to this bill. How would it change the rules of evidence?
It would make it improper to use lyrics in the way that we're discussing. That doesn't mean, of course, that if a person confesses and sings while they confess, that you could per se not use it. But what it would do is codify this idea that it's presumptively improper to use rap lyrics as evidence.
So why aren't the pretrial hearings that currently exist, right? A judge has a discretion to exclude evidence that is prejudicial, exclude evidence that is irrelevant. There is a ban on character evidence. Of course, there are exceptions, but generally character evidence where you're just arguing this is a bad guy in general isn't allowed. Why haven't those worked to prevent this issue?
Because judges are biased just like people are biased. Because judges are people just like people are people. And number two is that the blunt force of the conspiracy law basically says if these two people are associated with each other, if they're associated with anybody that's in the gang, if they're associated with another guy that's associated with another guy, they could be part of the same conspiracy. And so what the prosecutor can just say is, listen, this rap music, this rap video, it shows that they all know each other. It shows that they're all hanging out together. It shows that they're talking about the same kinds of things. It's completely misplaced and illogical if you strip away at it. But at first blush, it has appeal. It's like, okay, this does. It shows they know each other. It shows that they're talking about similar subject matters. And judges are mistakenly, in my judgment, letting it into evidence, or at least being swayed by it. It's even tainting the judiciary. It taints people at bail hearings. It taints people at sentencing. And the pros of using it do not outweigh the cons.
So under this new proposed standard, prosecutors would have to show by clear and convincing proof that there is a factual nexus between the lyrics and between the facts of the case. Can you give us a typical hypo where such evidence under this new standard would be admissible or inadmissible?
Yeah, I think that the only time it would be admissible would be if there's a clear nexus with great specificity of detail and temporal specificity. Okay, so what that means is, specificity of detail means the person is not rapping about somebody being shot in Brooklyn. They're rapping about the corner of such and such and such and such on such and such date. And that all lines up. And there's other corroboration that suggests that the person was present there, things they couldn't have just learned through hearsay. And if enough of that is put together, then it wouldn't block it. But they would have to actually have proof, not speculation and not just weaponizing and criminalizing the lyrics.
So part of rap music, right, is autobiographical in nature. And there's a component of it that is, I'm being real here. I'm telling you about life as I've experienced it. But the argument here is these rappers, they have personas, right? That is, Sean Carter isn't necessarily Jay-Z, right? So I guess my question is, where is the dividing line between Sean Carter, the person, and Jay-Z, the persona, when if you listen to a song, it seems like he's telling you his story?
Well, listen, I mean, one of it is, again, we get back to racial bias and the way that rap music has been looked at for the decades in which it's become the most powerful, important genre of music in the United States and hope and inspiration for millions and millions of people. But listen, when Bob Marley talks about shooting the sheriff, we don't look at him differently. Hulk Hogan throws somebody out of a ring. We don't think of him as violent. There's something in our society that looks at the black rapper as a criminal and also a black rapper. And that's the problem. They are becoming wedded together. And that's not fair. Now, when you say it's autobiographical, I would sort of put it differently, which is that it's a description of somebody's circumstances. Okay. The circumstances as they see them, rap can at times be. Just like the photographer that takes pictures of war-torn countries isn't part of the problem in the war-torn country. And just like people that write poetry about the sadness in their community aren't inspiring the sadness in their community. What they're trying to do is express their community as the way that they experience it. And the poet is not criminalized, the photographer is not criminalized, and the rapper shouldn't be criminalized.
So coming back to the letter, how much weight do you think having such big celebrity support has with the legislature and the governor?
Listen, I always tell folks, you know, if you're famous, if you're a celebrity, if you have a powerful voice that people listen to, you might as well use that for good. And so that's what's happening here. And when, you know, people with power, you know, speak truth to bad power, then people take notice. The media takes notice. Folks like you take notice. People are talking about it. It becomes part of discourse. And we hope that it moves the country forward and that it's progress, not just on this bill, but on bills that are passed in other states copying this bill and for the system as a whole.
I want to turn to your career because you've had this really interesting career. You started out at the CIA for a year, I believe, and then you go to the district attorney's office, and then you joined Ben Brafman's firm, the big deal defense attorney to the stars, and now you're at this big law firm, Quinn Emanuel, and you have a whole roster of clients that are huge names like Jay-Z, Mick Jagger, Naomi Osaka, Elon Musk, Robert Kraft, and many others. My question is, how is the litigation strategy different when your client is a star?
Yeah, well, you're taking me through, I mean, boy, you're talking about, you know, young fellowship all the way up through, and, you know, things change and circumstances change. But I mean, if you're litigating in the public light, things change. People take on personas, and their public image takes on a persona. The media and the public views them a certain way, and you have to try to humanize and make sense of why they do the things they do. They're people also, and you know, there are a variety of complicating factors. It's also the case that it creates complicated motivations in everybody, right? So it's not just that they themselves need to be interpreted and explained for all, but the way the media looks at them, the way the prosecutor looks at them, the way a plaintiff's lawyer, you know, sees them as a possible target for financial reasons and fame. It's a multi-faceted complication that comes with fame. And, you know, that's part of what you have to deal with.
So you've done over 50 trials. You teach trial advocacy at Harvard Law School. What would you say is one of the most important skills to master for a litigator?
The world is not black and white. The world is gray. And so if you can learn how to understand the gray in every fact pattern and how to explain that, and, you know, you understand that things are not as they always appear, and that humans are psychological beings, and that, you know, things are complicated, and you shouldn't just accept what you're being told, I think you start seeing the world and questioning things in a better, more productive way. And I think you can explain and convince a room of people that your way of looking at things is the right one.
Alex Spiro, thank you so much for joining me on Office Hours.
Thanks so much. Take care.